Hello and welcome to the This Week in Polity. Today we have taken up the news articles that you have seen, and most of the articles coincidentally today that we are going to discuss deal with the most important part of the Indian Constitution, that is fundamental rights. So there has been an analysis of evolution of Article 21 with respect to life and personal liberty, and the editorial also analyzed in detail as to what are the new and emerging threats on our liberties given especially under Article 21 but also in Article 19 and 20. Then, with respect to what had happened in Arjikar Medical College, the reward of life imprisonment and not going for capital sentence, saying that this kind of rape and murder was not the rarest of rare crime in India, and that's when the district court rewarded the guilty person life imprisonment, has brought the discourse around the capital punishment or the death sentence in our country. And so we are going to understand as to how the capital punishment might strike a balance between justice, deterrence, but on the other hand, it might compromise on various other things, especially human rights. Then there is a news where Bombay High Court has stated that use of loudspeaker does not constitute the part of the essential religious practice, and that becomes important for us to be understood from the point of view of constitutional secularism versus religious autonomy. And what is the thin line difference between these two? That line is drawn by the essential religious practice. Then Vice President Mr. Dhankar has stated that use of the triple underline whip has marred the freedom of speech and expression of the parliamentarians. So we are going to have a brief prelim-centric discussion around anti-defection law, main provisions, and also the what is a whip and how is whip manages the task within the parliament. And also the Supreme Court has now started considering the application of Article 127 and 128 with respect to the appointment of ad hoc judges and appointment of retired judges, because there is a vacancy at the level of Supreme Court and High Court, and there are lot of pendency of the cases. For that, the Supreme Court needs extra hands, and for that they are thinking of utilizing these provisions. So let's now quickly begin the discussion from the Hindu and Indian Express in last week. As you can see, the editorial that I just talked about is that Constitution at 75, constitutional justice and personal liberty. In the midst of marking 75 years of the Constitution of India, India needs to take a sober look at the right of personal liberty being core constituent of the idea of justice. If you look at the GS paper 2 syllabus, you can clearly see important features and the evolution as a part of your syllabus under GS paper 2. Now, not only Article 21 constitutes one of the most important article in the part 3, but also because it has evolved so much over time because of the judicial pronouncements that it becomes crucial for our performance in mains as well as in prelims. We'll see. The one question that I've shown here with respect to this exactly the same topic, the Constitution of India is a living instrument with capabilities of enormous dynamism. It is a constitution made for a progressive society, illustrate with special reference to the expanding horizons of the right to life and personal liberty. 2023 mains. You can clearly understand that at the center of this question is the idea of expansion of the rights that are available under Article 21 and how it has allowed the rights to evolve to allow for the progress in the society. At the same time, if you look at the prelims examination, easy questions, Article 2021, right to privacy is protected under which of the article of the Constitution of India? Which article of the Constitution of India safeguards one's rights to marry the person of one's choice, 2019? And right to privacy is protected as an intrinsic part of the right to life and personal liberty. Which of the following in the Constitution of India correctly and appropriately imply the above statement? The answer to all of them is Article 21 and Part 3. So, seemingly very, very small, probably the smallest article in the entire Constitution has become one of the most prominent articles of the Constitution of India. Just by looking at this bare act, I've taken this line from the actual Constitution of India, Article 21, which says that no person shall be deprived of life or personal liberty except according to the procedure established by the law, which literally read essentially translates into no person, which means that this right is available to all the persons equally, whether they are citizens or non-citizens. So no person shall be deprived of, which means that the deprivation of life is equally available to all the persons, or the deprivation of life and personal liberty of any person hangs by the thread of procedure that should come from a law. If you read this article, it basically means that the state under Article 12, utilizing the instruments provided under Article 13, can take away your, mine, or anyone's life and constrain or restrict the exercise of personal liberty for all of us just by a law passed by an ordinary majority, and that law should provide for a procedure to restrict our life and personal liberty. And we see that the state takes away lives of the people. In fact, death sentence or hanging till death is an exhibit of Article 21, because Parliament passed law, Indian Penal Code, provided for CRPC, Criminal Procedure Code, and in that provided for the state to take away lives of the people. But how has it transformed in last 75 years so much that it has become a centerpiece to entitle Indians with the human rights going above and beyond the fundamental rights? You understand that the dynamics or the entity of the articles, the variety of rights available under human rights, they are much more vast as compared to fundamental rights. And so in order to understand that, we will have to go a little bit into history and trace the evolution of this article divided into multiple pieces. And that's why I have color coded different important constituents of Article 21. So you see in the green color, no person, we have discussed that, shall be deprived of his life or personal liberty except according to the procedure established by law. And so how this particular constitution has evolved over time, the evolution traces the expansion of the keywords related to life, personal liberty, and the differing interpretation of procedures established by law, all of which we will understand now. Let's start with the procedure established by law. And for the time being, let's not talk about how life has changed or how personal liberty has changed. So let's say if we assume life is just a breathing life of an animal existence. So what the Constitution of India says is that the restriction on the state is only a procedural restriction, which means that as long as you satisfy the procedure established under Article 21, which means that you create a law in which you provide for a procedure, you can do anything and everything with people's lives. And that was the original interpretation of the Supreme Court initially just after the promulgation of the Constitution. Because immediately just after the promulgation of the Constitution, we have a very, very famous case under A.K. Gopalan versus Union of India, the landmark judgment of Supreme Court. And it essentially was centered around the interpretation of Article 21. What was this case? A.K. Gopalan, a prominent communist freedom fighter, as you can see on the screen, he was arrested by the government under a preventive detention law, which is governed by the provision of Article 22, not governed by the provision of Article 21. Article 22 provides for preventive detention laws, and it provides for minimum safeguards to all such people who are arrested under the preventive detention laws. A.K. Gopalan challenged the detention in Supreme Court, saying that under utilizing the provisions of Article 32, he challenged the detention. And when the court asked as to what is the basis of your challenge of such detention, because Article 22 provides the state to take away your personal liberty on grounds that you are about to commit a crime. That is what preventive detention, which is very different from punitive detention. And in this particular case, for the first time, A.K. Gopalan's legal counselors, advocates, tried to construe more than one article together to widen the horizon of fundamental rights. And so beautifully they presented their argument that later on in Maneka Gandhi, the same arguments overpowered every other suspicion on Article 21. And the argument is very simple. If you just are conscious and careful for next 5 minutes, it is extremely important for us to understand in order to be able to appreciate what Supreme Court has done and how it has endowed us with so many more rights without really amending the Article 21 through a proper procedure under Article 368. So without amending the constitution, we have been entitled with so many rights. It's amazing. It's so intriguing to see that. And so when in A.K. Gopalan case, the argument was that, sir, that's fine, that Article 22 provides for preventive detention, and we are not contesting that power of the state authorities to preventively detain people. However, sir, if you look at other articles of the Constitution, for example, if a person has been preventively detained, that person will not be able to exercise any of the rights that are provided under Article 19. So Article 19, 1A, 1B, 1C, 1D. Because if you are in jail, if you are under detention, you will not be able to make any speech or expression. You will not be able to participate in the assembly or association that you want to. You will not be able to move. Except barring maybe trade and profession or maybe right to property which existed at that point of time, all other rights exercised under Article 19 are being impacted because of the application of Article 22. And then the court asks, yeah, that's what we understand that, but what's the problem in this? And so A.K. Gopalan says the fundamental problem is, sir, that if the government or the state wants to restrict my Article 19 freedoms, the state can only do so on certain very, very limited criteria, which are known as reasonable restrictions. Which means that if the state has to restrict A.K. Gopalan from exercising his freedom of speech and expression, the state could not have done that beyond the reasonable restriction. If the state had to curb the freedom of movement of Mr. A.K. Gopalan, he could not have done that. The state could not have done that beyond the reasonable restriction, because if you read Article 19, it says that every person has these rights, but they are reasonably restricted. So for example, let's say in order for you to exercise your assembly, the right to assemble peaceably without arms, the state cannot allow you or can restrict the exercise of such right by a law insofar as it imposes or prevent the state from making any law in the interest of the sovereignty and integrity of India, in the interest of public order, and on the exercise of such rights. So you can see that sovereignty and integrity of India, public order are the only two grounds that the state can use to create a law to prevent people from assembling peaceably and without arms. Similarly, there are other restrictions, but beyond that, can the state restrict? The answer is no. And so the argument, obviously judges understand that where the arguments are headed. The arguments are headed in a very, very coherent direction, where the A.K. Gopalan is trying to communicate the idea that none of the articles are islands, but they work in sync, they operate in unison, there is a synergy between all the articles. Operation of one article directly impacts the entitlement provided under other articles. Just like the exercise of power under Article 22 clearly and openly violate people's Article 19 rights. And so the obvious question is that if there is a procedure established by law that takes away your freedom of speech and expression, and that law has been created not under Article 19, but that law has been created through the powers given under Article 21, would that be a valid law? Because if the answer is yes, then we have a problematic situation where Article 19 would not mean anything. If the state wants to restrict my freedom of speech and expression, why would state make any law using Article 19 too? The state can simply make a law under Article 21, because Article 21 says procedure established by law. Yeah, that's a law. That's fine. It takes away your personal liberty. We don't care. And that's when the argument was that, sir, if you look at it very closely, the law which takes away my personal liberty should be reasonable, because Article 19 ingrained within Article 19 are the reasonability of the restrictions. They cannot be unreasonable. And so you can see that element of reasonability was sought to be achieved because the argument was that Article 21 within itself contains inbuilt reasonable restriction. How can a particular law under Article 21 can be unreasonable when you have reasonable restrictions and the protection is available under Article 19? That was the genesis for the first time to read reasonability. The facts that you have heard that the law has to be just, fair and reasonable. Why that law has to be reasonable? Because there is Article 19. At the same time, even more decisive argument, more influential argument was made in this particular judgment. It was that if you look at Article 14, Article 14 provides for equality before the law and equal protection of the law. Equality before the law ensures check against the arbitrary action of the state. Because you have Article 14, it becomes an obligation on the state to treat everyone equally. And because you have the second clause of Article 14, equal protection of the laws, the state is allowed to reasonably classify people. But then that reasonable classification also has to be on the basis of intelligible differentia. But we are not going into that discussion. The fact that you have Article 14 means that the state is constrained by the fact that it has to treat everyone equally. And so the obvious question is that can state make laws or can state make arbitrary procedures? Because if the state can make arbitrary procedures, it undermines the sanctity of Article 14. But if you just read Article 21, Article 21 does not mention that whether it has to be arbitrary or a non-arbitrary procedure, because it just says the procedure should be established by law. And so does the question is, can the parliament pass arbitrary laws? Because if the answer is yes, it violates Article 14. And the argument was that if you read Article 14, Article 19 and Article 21, what we basically have is a trinity, a golden triangle of the fundamental rights, where any kind of procedure to take away your life or personal liberty under Article 21 has to be just, has to be fair, because any such law is subject by Article 14, and it has to be reasonable. But the court did not agree to such an argument. The court said that barely 1 year ago, in 1950, we have promulgated the Constitution, and there was a debate in the Constituent Assembly. And if they had wanted the law under Article 21 to be subject to just, fair and reasonable criteria, they could have simply written, no person shall be deprived of life or personal liberty except according to the due procedure established by law. But they removed the word due, which means that they did not want to constrain the state from taking away your life or personal liberty, and they wanted each and every article to operate in isolation and not in conjunction. And that's when the preventive detention and extended preventive detention of A.K. Gopalan was upheld, and he went on into custody for a very long time. But things had changed by the time the emergency had ended. And this was the landmark judgment of Maneka Gandhi, where ultimately Supreme Court agreed to the argument that was made in A.K. Gopalan. So it took around 27-28 years for the Supreme Court to usher in the era of liberal interpretation, going beyond the text. And that's when Supreme Court agreed that yes, any particular law under Article 21, which seems to be violative of Article 14, is an invalid law, and so automatically reading justice and fairness in Article 21. At the same time, every law made under Article 21 to take away your personal liberty also impinges your Article 19 liberty, and so such law has to be reasonable. And so Supreme Court basically amends the Constitution virtually to make Article 21 read as no person shall be deprived of life or personal liberty except by a just, fair and reasonable procedure established by a law. And so you can see insertion of 3 new keywords. A great transformation has come about in judiciary attitude towards the protection of personal life after the traumatic experience of the emergency. No article in this constitution pertaining to a fundamental right is an island in itself. Complete reversal of the thought process in higher judiciary. Article 21 would no longer mean that the law could prescribe some semblance of procedure, however arbitrary or fanciful, to deprive a person of his personal liberty. It now means that the procedure must satisfy certain requisites in the sense of being fair as well as reasonable, because if it is not, it would start violating Article 21. Because Maneka Gandhi's case was a case with respect to the Indian Passport Act, where she wanted to go abroad, and just on the airport, her passport was impounded, and she was not given any opportunity to be heard. And that's when she challenged this provision of Indian Passport Act, which said that the passport authorities have unlimited arbitrary discretionary power to impound or take away or cancel anyone's passport without even given reason. And so the fundamental question is that in a liberal framework which provides certain rights as fundamental, can you give any authority this kind of unchallenged power? Supreme Court struck that provision down because that was unfair, unreasonable, because it gave unlimited discretionary power to all the officers working for the Indian passport authorities. And so while applying that power, they are not being guided by Article 14 and 19. So every Indian passport authority and their officer they had the freedom to exercise such power in any way they had wanted, which violates the basic framework of Article 14. And that's when Supreme Court says that any law passed by the state, any executive passed by the state, any law passed by the parliament, which has to do anything and everything with life or personal liberty, would be subject to fairness, justness, and reasonability. And how Supreme Court then transformed the criminal law is even more intriguing. Just after the Maneka Gandhi case and the application of Maneka Gandhi case built upon this judgment, the reform of the criminal justice came. As you will see, I have collated all those documents at one place. So, for example, before 1980s, Supreme Court understood that any kind of procedure, any kind of legal procedure, in which people are not able to get the legal help, is an unjust, unreasonable, and unjust procedure. And Supreme Court mandates free legal aid for everyone. Long pre-trial confinement of prisoners is an unjust, unreasonable procedure. Any procedure which puts you and sends you to jail for many years without even being proven guilty is an unjust, unfair procedure. Strikes it down. And just for the sake of this limited bandwidth of this particular class, I'm not going to go into the entire reform that came. So that reform and these reforms were built around the liberal interpretation of procedure established by law. But what about life? Earlier, Supreme Court said life is just normal life. And then just after the emergency, Supreme Court transforms the life into the life of a human existence. And so deprivation of all those elements or limbs from which the human life is enjoyed, the state would be constrained by the procedure established by law. And that's when the Supreme Court starts widening the interpretation of life by first saying that what is life without livelihood? Because Supreme Court said by the term life here is meant something more than mere animal existence. The inhibition against its deprivations to all those limbs and faculties by which it is enjoyed. And so, if life is not pure breathing life, it is life of a human existence, whatever goes into enabling the human existence will be protected under Article 21. So without livelihood, there cannot be a human life. Without dignity, there cannot be a human life. Without clean environment, there cannot be a human life. And sorry, this is something from a previous. Without privacy, there cannot be any dignity. And because of that, privacy under K.S. Puttaswamy judgment is read under Article 21, further widening the ambit. Then utilizing the privacy, homosexuality was decriminalized. Built upon privacy, the Supreme Court struck down the adultery law. And so you can see it has provided for a progressive society. I hope it is clear to everyone. So you can see that it changed the arrest. So it modified the long pre-trial confinement. It modified things. Death sentence is something that we'll do separately because that is a part of the next discussion. It modified life into livelihood, dignity, right to marry, right to privacy, right to clean environment, pollution. All of that creates human existence, and all of that shall be protected under Article 21. However, what about passive euthanasia? How was Aruna Shawbag given the entitlement to end her life? That is something that is not given to anyone else. Supreme Court says that while we are trying to protect human existence, what if there is a case where the life becomes impossible in a human body? So, human life and the enjoyment of the limbs and faculties within a human body becomes impossible. That should be ended because that is a life of an animal existence, and allows for passive euthanasia where you remove the medical support and that's when person dies, as opposed to active euthanasia where you inject something to actively end or pursue the end of life. So you can see that that's how, I mean, it's much wider, but it takes more time to discuss Article 21 because it's much more nuanced. But this will enable you to address all the issues when it comes to prelims or mains examination. Let's quickly try to solve the question in mains. The Constitution of India is a living instrument with capabilities of enormous dynamism. It is a constitution made for a progressive society, illustrate with special reference to expanding horizon of right of life and personal liberty. So you can understand that the main demand of the question is that you have to prove as to how Article 21 has widened and what are the extra rights that we have come to enjoy as a result of this. So that's the main demand of the question. Although the editorial highlights emerging threats to personal liberty, preventive detention laws, arbitrary arrest, curtailment of free speech, crackdown on activists and NGOs, internet shutdown, data privacy, and judicial delays, they continue to mar the enjoyment of Article 21 and its widened ambit as of now. So I will upload the PPT. You can understand if you are following the newspaper and focus weekly videos, you will understand that we have covered some of these before as well. So these are the threats that still prolong. Death penalty in India legal framework. RG Kar rape and murder, lifelong imprisonment for convict Sanjay Roy. Court says it will be inappropriate to accede to the prosecution's request for death penalty as case cannot be classified as rarest of rare. So what is rarest of rare doctrine? Victims' parents refuse compensation, say they want justice. Mamata Banerjee says her government will plead for capital punishment. Again, it deals with something that we have discussed in Article 21. But death sentence in itself is a vast topic. So let's see what has been the Indian law. I mean, this has changed a bit because we have now adopted Bharatiya Nyaya Sanhita and Bharatiya Nagarik Suraksha Sanhita. So these sections would change, but the wordings have not changed. And so why we are looking at the old law? Because in order to understand the evolution of rarest of the rare doctrine, you will have to situate yourself in the law as it existed before 2024, which is Indian Penal Code. So Indian Penal Code section 302 provided for punishment for murder. Whoever commits murder shall be punished with death or imprisonment for life and shall also be liable to fine. And so you can see that a person, once it is proven that the person is guilty of a crime of murder, can either get a death sentence or can either get life imprisonment. And so you can see that in the hierarchy of punishments, death sentence is the highest, and just below that, you have life imprisonment. However, there is a stark difference between life imprisonment and death sentence. One is reversible, another one is irreversible, irrevocable. But the question is, what is the procedure? Because procedure is key under Article 21. What is the procedure which will help the district judges to determine that one person should be given, handed out life imprisonment, or that person, that case is fit enough for hanging? And for that, we had section 354(3) Criminal Procedure Code, which says that when the conviction is for an offense punishable with death under 302, or in the alternative with imprisonment of life or imprisonment for a term of years, the judgment shall state the reasons for the sentence awarded, and in the case of sentence of death, special reasons for such sentence has to be written down. Again, you can see on what basis or what can be some of these special reasons which will help the judges determine whether it should go for death sentence or whether it should go for life imprisonment is completely missing, and it gives absolutely discretionary power, arbitrary discretionary power in the hands of the district judges to apply their own personal morality to determine which one of the judgments would actually be handed out. And you can see scope of violation of Article 14 right here. Because from judge to judge and from their personal experience of life and their personal moral compass, one act might look more heinous than other to one person as opposed to another person. So for someone, 5 murder and 2 rapes might constitute like an okay crime, and just 2 murder of a prominent person in the society might look like a very heinous crime. Whereas for two different people, the same act, same offense of murder can attract different response, and there was a huge scope of arbitrary action under section 354 clause 3, and that's when it was challenged in Bachchan Singh case. When Supreme Court upheld the death penalty was also challenged, but Supreme Court said that obviously death penalty has been provided by the constitution, so we cannot say. If you look at various provisions of the constitution, for example, if you look at pardoning power of the president and the governor, it death penalty has been mentioned, so it is allowed by the constitution, so we cannot disallow the death sentence as of now unless and until it is amended by the parliament through a proper procedure under article 368. The Supreme Court upheld the death penalty but emphasized that it should be imposed only in the rarest of the rare cases where there is no possibility of the reformation. And now you can see Supreme Court is trying to build a reasonable classification within all the cases where the person is guilty of murder, because all the murder cases cannot be same. And so you need to create a differentia, you need to create a parameter where rest of the cases will go for life imprisonment, but only certain extreme grave, the cases which shake the conscience of the society, only those cases should be fit enough. And Supreme Court lays down the criteria to determine which one of them would be rarest of the rare cases, so that the exercise of the power given under 354(3) cannot be applied by complete arbitrariness or to reduce the discretionary power of the district judges. And that's when it says that we are laying down aggravating circumstances and we are laying down mitigating circumstances, factors which could tilt the decision towards death penalty and the factors which could tilt the decision away from death penalty. So while writing down the judgment, it became obligatory on every judge. Whenever they go for death sentence, they have to justify that by clearly showing and following these guidelines. What are these guidelines? Supreme Court says that if the murder is pre-planned, calculated and involves extreme brutality, that is a case of aggravating circumstances, which means that the odds are in favor of death penalty. Show it by clearly articulating the nature of pre-planning, calculativeness, and also the elements of extreme brutality in that particular instance. If the murder involves exceptional depravity, if the accused has been found guilty of murdering a public servant, police officer, or a murder of the armed forces while discharging their duty, if this is the case, then it fits the case of rarest of the rare. But if there are certain other elements, it should reduce the probability of awarding death sentence. What are those cases? If the accused was under extreme mental or emotional disturbance at the time of the commission of the offense, age of the accused would not be given death sentence if they are very young or very old. Probability of the accused posing a continued threat to the society. So if you see that there was an extreme circumstances in which the person committed the crime, but the person is not habitual offender, and probability of him committing any further crime in the rest of his life is very low, then you might not go for death sentence, go for life imprisonment. Probability of reforming the accused, if the accused person, guilty person, has shown signs of reformation or penance, if the accused was acting on the direction of another person, which means like a contract killing, if the accused believed their actions were morally justified, if the accused suffers mentally and is unable to appreciate the criminality of their action, if all these elements or some of these elements are present, write them down and then decide on the basis of which one of them weighs heavier and then go for either death. So you can see an element of justice and fairness in the application of death penalty has been encoded, and this is what is known as rarest of the rare. Just to differentiate between less rare and more rare crimes, only in extreme cases the death penalty shall be given. However, that has not put to an end debate hovering around capital sentence. There are equal number of scholars and commentators who support the continuance of death penalty in India, and then there are equal arguments against the continuance of the death penalty in our country, the most vocal being Justice Bhagwati himself. So let's look at the arguments. If you are not able to read the arguments as of now in YouTube video, you can just download the PDF, and where you will see the same slides over there. Arguments, let's first go through the arguments in favor of death penalty. You need deterrence against heinous crimes. Proponents argue that the death penalty serves as a deterrent to potential crimes, and political philosopher Immanuel Kant himself has said, if an offender has committed murder, he must die. Then every kind of punishment has an element of retribution. Every punishment is not meant to reform people. So capital punishment satisfies the moral imperative of retribution, delivering justice to victims. Punishment must be deserved and proportionate to the crime. In India, the judiciary in Bachchan Singh case upheld that the death penalty could be imposed in the rarest of the rare crimes to uphold the same justice. Then you need elements and tools to protect the society. Advocates contend that the death penalty permanently removes the dangerous criminals. There are certain people whose mindset have become so hardened that there is no scope of reformation. Public opinion tilts heavily in favor of the death penalty, and so in order to ensure national security, to ensure the security of and integrity of our country, you need some death penalty mechanisms. However, researchers have shown that the deterrence value of death penalty is extremely low. If every person who is caught of murdering the people probably knows that after committing such a crime of rape and murder, there is a probability of hanging till death. There is a probability that they will be awarded with the death sentence. But does that prevent people from raping women and committing murder? It does not. And so research shows that the death penalty does not effectively deter crimes. Amnesty International 2000 report says there is no empirical evidence that the death penalty deters crime more effectively than other forms of punishment. In fact, there is an article that you can read in 2021, The Hindu, M.A. Farooqi. He writes that the Nirbhaya case has not significantly reduced sexual violence, highlighting the failure of the deterrence. The case in which all the guilty people except the one were hanged till death. We don't see any significant reduction in rape and murder. Also, because of its irrevocable and irreversible nature, death penalty does not gives you to course correct. There are so many flaws in the police investigation. There are so many flaws in the judicial process itself that it often happens that the justice, when it is finally delivered, it is delivered in a wrong way. And let's say if a new evidence emerges after 10 years of execution of the person, how are you going to restore the life of the person? And so it says that capital punishment is irreversible, and errors in the justice system can lead to wrongful executions. Justice V.R. Krishna Iyer, in his book Law and Life, says that the irrevocability of the death sentence makes any judicial error fatal and unjust. The Law Commission of India, in its 262nd report 2015, recommended abolishing the death penalty, citing the risk of wrongful convictions. Also, the fact that Supreme Court has created rarest of the rare doctrine does not mean that still its application will not be discriminatory. Critics argue that the death penalty disproportionately affects marginalized communities, because marginalized community do not have the resources to hire good lawyers. And because they cannot hire good lawyers, the challenge to the death penalty is on very weak legal grounds, mostly on the lawyers provided by the state themselves. And that creates a huge tilt. If you look at the data, people from the marginalized community are the receiving end of the provision of death penalty. Obviously, there is a global trend in the world where more and more number of liberal democratic countries are getting rid of the death penalty, realizing its futility. And so alternatives like life imprisonment without parole is suggested as a more humane and equally effective alternative. So these are two sides of the same coin. If there is a question in mains with respect to which one of them, it's not important for you to take the sides. It's important for you to be well versed with all the dimensions, and then depending upon which one seems correct to you, you can take either one of the sides. Let's now move on to the essential religious practice and understand where did it come from. Why Bombay High Court said use of loudspeaker is not essential to a religion or to any religion. High Court was hearing a writ petition filed by two residents association in Mumbai's suburban Nehru Nagar, Kurla and Chuna Bhatti areas against the use of loudspeakers by the mosques and madrasas beyond permissible decibel limits and during prohibited hours. And how does it get connected with your syllabus? Is because there is an article 25 and 26 which provides certain religious freedom or freedom related to the religious activities, and the fact that Supreme Court has mentioned these articles. So let's first go through and understand the provision of these articles and then see how within these two articles, if you read between the lines, you can see how we can derive the essentially religious or the principle of essentiality. Article 25, freedom of conscience, which means that you have absolute right to decode, devise your own conscience. Free profession, which means your ability to admit openly your conscience. Practice and propagation of religion, subject to public order, morality, health. The only article which starts with the restriction. The article does not start with the right. The only article in fundamental right which starts with subjection, which means forget about the religious freedom, subject to public order, morality and health, and to other provisions of this part, which means our freedom of religion is not just cannot be restricted on the basis of public order. Yes, it can be. Health, yes, it can be. Morality, constitutional morality, yes, it can be. If you create a new religion which is constitutionally immoral, you will not be allowed to do that. But it says a general statement, and to other provisions of this part, all persons are equally entitled to freedom of conscience and right. And why this is the case is because of the statement given by Ambedkar in Constituent Assembly. We ought to strive hereafter to limit the definition of religion in such a manner that we shall not extend beyond beliefs and such rituals as may be connected with the ceremonials which are essentially religious. And so, how do we do that? Why did I show you this? Is because the next clause exactly translates the thought process of Ambedkar into a constitutional legal language. What it says is that nothing in this article shall affect the operation of any existing law to prevent the state from making any law which regulates or restricts any economic, financial, political, or other secular activity which may be associated with religious practice. So Ambedkar first makes a statement which says that the guarantees in this constitution, they are not available to the exhibition of religion that goes beyond what is essentially religious. Because every religion comes up with a lot of non-religious activities. Is it the responsibility of the state of India to protect every such non-religious activity? No. And how does it transforms into a constitutional or legal language is when it says that the state has full right to regulate something that is anything except or anything beyond essentially religious. Because if anything is economical or financial or political or any other secular, which means it is not religious manifestation of that particular religious activity, and it can be rightfully regulated by the state. But this is generally about religion. We know that not every religion exists in the form of monolith. Every religion consists of multiple sects, multiple groups which are known as religious denomination. And that's when you have Article 26, which deals with freedom to manage religious affairs subject to public order, morality and health, the same ones. But here, other parts of this, other provisions of this part is not mentioned. Every religious denomination or section there shall have the right to establish, maintain institution for religious and charitable purposes, fine, to manage its own affairs only in the matters of religion. Which means, if you club Article 25 Clause 2A and Article 26B, what you create is that to both religions as well as religious denomination, they have a complete autonomy of operation only as long as that particular element is religious. Anything that goes beyond religion into politics, into economics, into finances, into properties, that is not protected by part 3, that will not get the guarantees of fundamental rights, And that's when you can see and appreciate him, basically, because he said that we ought to strive hereafter to limit the definition of religion in such a manner that we shall not extend beyond beliefs and such rituals as may be connected with ceremonials which are essentially religious. What it basically means is that if there is a religious practice that seems to be, let's say, violative of fundamental rights, can the state regulate it? If the religion is able to prove, or the followers of the religion are able to prove, that this particular ritual or this particular practice constitutes the core of the religion, then the state cannot regulate it. However, if the group of the people following that practice fail to prove this, then it will become subject to fundamental rights. And the application of this essential religious practice has done or brought various reforms, especially with respect to gender justice. Entry of women into Haji Ali, entry of women into Ayyappa temple was rooted in the interpretation of essential or application of ERP, essential religious practice, because both these religious denominations failed to prove that denying entry to women constitutes the core. Now, because they were not able to prove that, now the fundamental right will become applicable. And fundamental right under Article 15 says, the state shall not allow or not discriminate on the basis of religion, race, caste, sex, place of birth. So on the basis of sex, how can you differentiate? Because it is not religious, but it is a secular activity. It does not constitute the core of the religion. So you can see that relevant articles are this. The first time in Shirur Mutt case, religion will cover all rituals that are integral to a religion. Entry of women in Haji Ali and Shani Shingnapur, Sabrimala, India Young Lawyers Association, triple talaq, null and void, because triple talaq, Muslims fail to prove that triple talaq is or that constitutes the essential religious practice. Parsi women married outside community allowed to participate rituals. So what it seems to us, if we belong to progressive thought process, it seems to us that this is such a wonderful thing, because through essential religious practice doctrine, what Supreme Court has done is that it has allowed the constitutional morality, the norms and the values ingrained within the constitution to overpower social morality, because denying entry to women is societal rule. And because they did fail to prove that their religion also demands that, it was basically the later modification that was adopted from the societal practice. And so it was struck down. That's number one. But at the same time, it protects what is essentially religion. So by drawing a thin line between what is religious and what is not religious, what is essentially religious and what is beyond essentially religious, in a way, Supreme Court has allowed complete 100% protection to the core of the religion. So it said that it could be anything, but if you are able to prove it forms or it constitutes the core, we are not going to touch upon it. So you be assured of your religious freedom, but anything that gets added on from society later on, then we cannot guarantee the protection. And so it provides primacy of rule of law rather than rule of the religion. You do not give the autonomy to religion to determine what is religious and what is not religion, and what is protected by the constitution and what is not protected. However, there are certain fundamental problems with this doctrine. Number one, courts are not the forums to solve theological questions and ask theological questions related to religion. Since when the judges trained in modern law became the determinants or became the judges of the religious laws and to interpret the basic text. Also, there is fundamental problem that there is a lack of uniformity in deciding ERP. Supreme Court has not clearly laid down as to, while determining what is essential and what is not an essential religious practice, what are some of the parameters that they are going to deploy. Sometimes they consider the basic text, but not every religion has a basic text. So in that case, how will they determine? There is no uniformity, and because of which the Supreme Court judgment itself has varied with time. Obviously, you cannot deny that by taking away the right from the religious and the followers of a religion, shifting it to the court's arena, the Supreme Court has impinged on the autonomy of the religious denomination, because now it is the Supreme Court which will determine rather than the followers or the adherents of that religion. And so, in some cases, and this is the most important argument, in some cases, let's say, there is an extreme brutal ritual in a particular religion. For example, female genital mutilation in Bohra communities. If the community, and that the problem, community has been able to prove that, sir, this is an essentially religious practice, this is a core on which hinges our belief and faith, worship, then that becomes protected. So while the application of this doctrine in last 5 years has ushered India into the era of gender justice, its application have also been in a way that have gone against the gender justice. So if you are able to prove openly discriminatory practice as essentially religious, you are allowed to carry forward that. How can a judicial pronouncement allow for openly discriminatory and brutal practices to sustain? So you can see that there are both sides of the coin here. So benefits of the essential religious practice and the negative effects of essential religious practice doctrine I have provided in the notes. Let's now quickly cover the two news articles which are mainly relevant for the prelims examination. Mr. Dhamkar has made this statement that the way parties are using whip, which means the way they are issuing orders to their MPs and MLAs to follow through on particular behavior that they have to exhibit on the floor of the houses, has taken away the freedom of speech and expression. The whip system that Dhankar wants abolished and how it can be adopted. So we will not discuss this into detail. Through 52nd constitutional amendment, 10th schedule was added, which created roadblocks on the people who wanted to shift political alliances, and it induced certain minimum level of liability on them, which means that if you voluntarily resign from the primary membership of the party, you are not allowed to be a part of the house in which you were elected. And similarly, so let's quickly go through the rules. So what it says is that voluntarily, if a person gives up his membership or does not follows the orders of the party, then it will be constituted that they have resigned voluntarily from the party, and they will be disqualified by the speaker or any presiding officer, if the case may be. However, there are other people also. So you know that members are nominated in Rajya Sabha. So if they are nominated, they might not belong to any particular party because they have not contested election. And at the same time, there are a lot of independent MPs and MLAs who get elected very often. So independent do not have any choice. They cannot join any party. If after being elected, they join any particular party, their candidature will immediately be disqualified. At the same time, nominated members get a period of 6 months before which they can make the decision. Beyond 6 months, they do not have any option. If they join it, they will be disqualified. They can be disqualified. The discretionary power is with the presiding officers. However, there are exceptions given. If a person becomes a presiding officer, in order to ensure the neutrality of the position of presiding officer, the opportunity is given that you might resign. That will not constitute as a violation of 10th schedule. At the same time, if a political party with the support of 2/3 of its parliamentary members merges with another political party, the remaining 1/3 would not be constituted to have defected from the party. Why this kind of a rule was needed? Because it was understood that when a person gets elected to become an MLA or an MP, there is an element, there is a contribution coming from both political party as well as the members' own personal credibility among the population. And so if you decide to switch the political platforms, you would have to let go the votes that you were entitled to as a matter of fact, because you contested from a political party, from a particular political party, and so go back and retake the mandate from the people. And so in order to actualize the provisions of 10th schedule, parliamentary convention established whip system. So what is a whip system? Whip is a person who is both the part of the organizational party as well as a parliamentary party. Through the whip, organizational party, which means the party headquarter outside the parliament, gets the order issued to be communicated to all the members. So for example, if a particular political party has 80 MPs, one of them will become whip, and that whip will be connected to the party headquarters. So party headquarters will contact the whip that today there are 3 to 4 resolutions and we want our MPs and MLAs, as the case may be, to vote in this particular fashion. Now it is the responsibility of the whip to issue a document If that order is underlined once, it is called one line. If it is underlined twice, it is called two line. If it is underlined thrice, it is called three line. And in the order of increasing seriousness, there is a flexibility that is given. So, for example, there is a minor resolution which does not directly impact the policies of the government. And ruling dispensation, let's say BJP in this case, asks the whip to issue a one line whip underlined once, gives the freedom to abstain. So order has been issued, but you can ignore it. If you want to chill outside the parliament and not attend the meeting on that particular day, it's fine. You will not be held responsible. However, twice underlined means that you have to attend, but you have the freedom to vote. But if it is underlined thrice, which means not only you have to be present, absence will constitute a disobedience. By the same time, you will have to vote in the fashion as recommended by the whip. And if you do not follow through, then you will be liable for disqualification. And so we are not going into detail as to how it has done a lot of damage to India's representative democracy. It has hit at various places, but just from the purpose of prelims examination, this is more than sufficient for us to understand why Supreme Court suggested appointing retired High Court judges on ad hoc basis. The Supreme Court as well as some earlier law commissions have previously batted for such appointments and laid down detailed guidelines for it. Article 126, 127, 128. This particular article deals with Article 127 and 128. Appointment of ad hoc judges. If at any time there should not be a quorum of the judges of the Supreme Court available to hold or continue any session of the court, now this has been struck down, the Chief Justice of India may, with the previous consent of the President and after the consultation with the Chief Justice of High Court concerned, request in writing the attendance at the sitting of the court as an ad hoc judge for such period as may be necessary of a judge of a high court duly qualified for appointment as a judge of the Supreme Court to be designated by the Chief Justice of India. Which means that there can be a situation where number of judges in the Supreme Court are very low, which impacts the disposal of the cases. The Chief Justice of India will first seek the permission from the from the President that, sir, we have around 7 to 8 people not able to work for some time. Why not go with the judges of the High Court, which are otherwise they qualify the criteria to become the Supreme Court judges. So we are not going to violate or dilute the people. All the people who are otherwise fit enough to become the judges of the Supreme Court, we will ask them, and then they will request the respective Chief Justices of the High Court that we want this person from your High Court, that person from your High Court, this person from your High Court, and that's when you can see it shall become the duty of the judge who has been designated in priority to other duties of his office to attend sitting of the Supreme Court at the time and for the period for which his attendance is required. He will leave all the work, she will leave all the work and immediately join Supreme Court, and she will act. And for the time that they act as judges of the Supreme Court in an ad hoc fashion, they are not the puny judges, they are not the normal permanent judges. If they work, let's say for 4 months, for that particular period, they will be entitled to such powers, privileges, as long as they discharge the duty of Supreme Court. Once it is done, they will go back. But at the same time, you have a large reservoir of the retired Supreme Court judges. Why don't we use them? For them, we have a separate article in the Constitution, Article 128. Attendance of retired judges at the sitting of the Supreme Court, notwithstanding anything in this chapter. Chief Justice of India may at any time, with the previous consent of the President, request any person who has held the office of a judge of the Supreme Court or Federal Court and is duly qualified for appointment as a judge of the Supreme Court to sit and act as a judge of the Supreme Court, and every such person so requested shall, while sitting and acting, be entitled to such power. So you can see that the Supreme Court has power to use both the High Court judges as well as the retired judges of the Supreme Court as and when there is a situation where the normal day-to-day disposal of the cases cannot be taken care of, either because there are less number of judges or because suddenly there are so many cases that it has increased the overall workload at the level of the Supreme Court. So these are the short notes that you can see on the screen. That's it for today. Do let us know if you have any doubts with respect to any of the videos that we are doing these days in the comment section. The faculties will get back to you with the resolution of the doubts. Stay tuned. All the best.